Oh,
Yes, sir, I am reporting now.
okay, pal.
This is item MI 2024-003-928 for the property located at 60 North 23rd Street. The underlying violations in that case have been complied, so it is, I guess, a moot decision to the board.
Okay, fine. Fine. Next case will be 4243 Sampson Street. Let me see, who's here from 4243 Sampson Street?
Hello, Mr. Miller. Richard Coe on behalf of Sheila Fullwood, the owner of 4243 Sansom, and also on is Adib Mahdi, who's her architect.
Okay, Adid, okay. Let me see, Richard, you're a lawyer, right?
Yes, I am.
Okay, I don't have to swear you in. Is Ahmad, is he a lawyer?
No, he's not.
Okay, Ahmad, please raise your right hand. Swear to tell the whole truth, nothing but the truth?
I do.
Okay, is there anyone else going to be testifying?
No, just Mr. Mahdi.
Okay, my name's Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
Ryan McSherry, board counsel.
Matthew Wojcik, LNI supervisor.
Philip Motto, Boards Administration.
Excuse me, this is the reporter. Could I please have the witness, Mr. Mahdi, spell his first and last name?
ADIB, Adib, last name MAHDI.
Thank you.
Before we start, I see that Mr. Coffey is on the Zoom call. He's the owner of the adjoining property.
That's not the case.
Yeah.
That's the next case. We're going to do that separate.
Okay.
Okay. All right. Tom, you want to give us a little bit on Sampson Street?
Can I put that one in the record first, sir?
Oh, I'm sorry. Tom, please raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth.
Yes.
Okay. Give us a little bit on Sampson Street.
So actually, this matter involves the party wall between the two properties at 4243 and 4245 Sansom. 4243 Sansom is an occupied property, and 4245 is a active construction site. So I do believe that both cases should be heard at the same time, and with the merits of the case in front of the board.
Okay, if you feel that way, is there any different people going to be a witness on 4245 Sampson Street?
Yes, members of the board. Alexander Barth on behalf of Cohen Seglius, here with Brian Jeffers of Cohen Seglius on behalf of Red Rocks Group, which is the owner of the adjacent property. I'm here with Ethan Fellheimer. And
who? Hold on, let's get down. You're a lawyer, right? You don't
Yes.
have to get sworn in. You guys tell the truth all the time.
Yeah.
Now you have Brian. You a lawyer, Brian?
I am.
Okay, you don't have to get sworn in. Is there anybody there that isn't a lawyer?
We're both lawyers, but we are the property owners as well.
Okay, but well,
Yeah, we hold licensed bar cards.
yeah, well, okay. Anyone else that's not a lawyer going to be testifying?
Just to interject real quick, I am a lawyer, Hal Coffey, on behalf of Franjo Construction Corporation. We were also named, my client was also named by this and received the notice today. So
Okay, if you lawyer, we don't swear lawyers in, okay? So that's all I want to get straight. All right, again, I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
Ryan McSherry, board counsel.
Matthew Wojcik, LNI supervisor.
Philip Motto, Boards Administration.
Okay. Phil, could you read both cases into the record, please?
Yes, sir. The first item is MI 2024-007-157 for the property located at 4243 Sansom Street. The next item is MI 2024-007-196 for the property located at 4245 Sansom Street.
Okay, we're ready to go. Tom, give us a little bit about these two projects.
So essentially, we have the property at 4243 and 4245. The common shared party wall has a fracture that is running up the side of the wall. The fracture was there prior to construction, but while construction or during construction, it appears that this fracture widened. We were notified by the contractor at the site of the construction at 4245 that their monitoring device, their crack monitoring device, had alerted them that there was some sort of movement of this property, which facilitated the department to issue an unsafe case against the property and also issue a stop work order against the construction site. Following an inspection that was done and also an inspection by the department was provided an engineering report for the occupied property. Following that report and the inspection done by the department, the property was declared as eminently dangerous, as it appeared this crack is starting to widen. And
You have
could affect
pictures?
the property being occupied, and it could affect the ongoing construction at the site at 4245. The appeal that has been filed for 4243 Sansom, in the body of the language of the appeal, that they've engaged the services of an engineer, and that a permit would be applied for on or around the week of November 25th. Prior to today's proceedings, I did check the system, and a permit application has not been provided to the department. So I would like to get an assumption of when that permit will be submitted for review by the department. And secondary, it is critical that we receive a report that the property at 4243 is in fact able to be occupied. With that said, I'll share my screen and show the conditions that warranted the case issued against the property.
Excuse me if I may interrupt. I believe it would be proper if again the attorneys who are also the property owners, if they're going to be providing testimony, I think it would be proper for them to be sworn in.
Sure, I can sign. Sure.
Okay, is that what you want? No problem.
Uh,
All right. All right, all the attorneys are gonna be property owners. Who's that? Brian and who else?
It's Forrest Passerin and Ethan Fellheimer.
Okay, we'll do one at a time. Ethan, we'll take you. Please raise your right hand, swear to tell the truth, nothing but the truth.
So help me God.
Okay, Brian, can you please raise your right hand, swear to tell the truth, nothing but the truth?
Forrest. Forrest.
Oh, Forrest, I'm sorry, Forrest. I can't see the forest through the trees, but sorry.
Sorry. I do.
Please raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Okay, anybody else?
Apparently, Franjo is supposed to be on the phone. They say they are. I don't see him on screen, but their testimony will be helpful here as well, just for the, there we go. There's Brendan.
Okay.
Excuse me, this is the court reporter. Because there are three gentlemen, could I please ask you to identify yourself when you speak?
Oh, what the heck's that? Okay, you want, John, you want them to tell your name and to spell it?
Yes, please.
Okay. Ethan Fellheimer, ETHAN, F as in Frank, ELL, HEI, M as in Mary, ER.
Okay,
All right.
next guy.
Forrest, Forrest. Last name is Passerin. It's Passerin.
Okay, is there any other lawyers?
No other lawyers, but there are two gentlemen on the under Brendan Gallagher's name that are with the construction company being represented by Mr. Coffey.
Okay,
And
Brendan, is that, Brendan, please raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Who's the next guy with you?
Frank Hewitt.
Hey, Frank, please raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Okay, let's go. Come on, Tom, continue.
Okay, with that, I'll share my screen and show you the conditions of the properties. Everybody see my screen?
Not yet. We see the screen, but no pictures come up. There we go. There we go.
Okay, so this is the property here, the photo on the left-hand side of the screen. This is the property at 4243 Sansom.
Okay,
This is the side wall of 4243, but the side wall of 4245 is the construction site, and the fracture runs from the foundation all the way through, all the way up to the roof line of the property.
Tom, that construction site, what are they building something? Building a new house there?
It's a large construction site with an issued building permit that covers multiple parcels.
Okay, that wall on the left-hand side that I'm looking at is fractured from the top to the bottom. Is that connected to the house next door? I don't
It
see
is.
a house next door.
It is. It's the party wall between 4243 and 4245, which is not the vacant lot, but it's the active site.
Yeah, uh-huh,
Mhm.
okay, all right.
Another illustration of the property and the fractures that are going on with that wall. And then you can see that there's a monitor on the fracture. And then this is a close-up of the view at the roof line with a copy of the posting.
Mhm.
And then this is I'll spin it.
Tom, do you have a picture from the other side of that wall?
That would be actually included in a report that the department received, and I believe it is part of the packet that is going to be brought into the matter in front of the board.
Okay, all right.
But
So you're-
essentially, what we're looking for is the permit for the repair of 4243, which the department believes that 4243, the repair would satisfy the repair of the party wall of 45. I believe it's a matter between both property owners, but essentially we would be looking for a permit to be issued within 30 days for the repair of the property.
Okay, all right, all right,
Can I ask
so.
Can I ask you a question? So you're
Go
saying
ahead.
the crack was there prior to construction starting?
Yes.
And then what construction had been done that it is now widening? Or do we think it's just a temperature change?
All we know is that the department was notified by the construction company that was doing the work out there that their crack monitoring equipment made them aware that there was movement and the crack was widening.
Tom, it appears that there was some patching of the crack at some point in the past. Was that done by 43 or 45 or and has that happened during the time that the construction has been ongoing next door?
You actually look at the street view either via Google or the City Atlas website. You can actually see that prior to construction, this fracture was on location. It was there. There was some sort of mortar applied. I can't say who applied that mortar, whether it be 43 or 45.
We can attest to it. We can testify that it was not us.
Who's we?
The owners of 45.
The owners of 45, okay.
Could I please ask who's speaking?
Ethan and Forrest.
Okay, continue.
But again, what construction has happened since that crack has widened?
Brendan.
Was there excavation?
Yes, so this is Alex Barth on behalf of Red Rocks Group, the owner of 45. When the department was notified that the crack was widened based upon the monitor results, a stop work order was put on place on 4245 Sansom Street, the ongoing construction project. So nothing has happened since the department was notified.
That's not entirely true, but go ahead.
Well, there's a stop work order, so it has been, but prior to that, there is the construction of a four-story?
Three-story.
Three-story structure on 4245, 4247, which is now a consolidated lot. That is going up. That construction is not immediately adjacent to the wall. There is vacant ground between the new structure that is being built on 4245 and the adjacent property at 4243. So the excavation, foundation, everything that is taking place on 4245 is set back away from this, as the department is calling it, a party wall. It is not directly adjacent to it. There's no underpinning going on. There's no alteration, modification of the existing foundation at 4243.
How big a gap is there between the two buildings?
8 or 9 feet.
Has there been any, pile driving or any kind of activity that would have caused, vibrations that arguably could have, transferred that distance?
We switched the piles when we put the equipment originally on the site.
This is Forrest Passerin. Brendan, if you could describe what was installed on the site, that would be appreciated.
This is Frank Hewitt. As permitted, it was a GeoPure. The owner had installed a vibration monitoring system in accordance with the guidelines of Philadelphia. We mobilized that rig, and upon mobilization, the acceleration of the ground exceeded the parameters permitted by permit, and that operation was stopped. We went through a mitigation process with the city and ultimately settled on a modulus pile, which is a drilled pile, and then concreted in so that it doesn't have vibration. Those vibration monitors continued throughout that activity, and none of them met the acceleration requirements. We were within the acceleration requirements. None of them exceeded the acceleration requirements. Upon completion of that, we started excavating for the shoring, and that's when.
And that's for 45, right?
Correct.
Pardon me?
That's for 43, 45.
Correct.
Okay, go ahead.
We were excavating on 45. Yes.
Right. Okay.
We had began excavating on 45 to start putting in the basement level. We made it down about 3.5 to 4 feet. And that's when we noticed the building was moving. So it wasn't during the piling operation.
And you noticed 43 was moving.
43 was moving, yes.
Okay.
That's when we stopped and notified everybody, and that's what brought us here today.
Okay. My question, Tom, to you. That wall that's up there.
Yeah.
Okay. Half of that wall's 45 and half of that wall's 43?
That's the department's belief, yes, unless a survey was provided that the property line had moved over for 45 and the wall is 100% 43's responsibility. But it is the department's belief that this is a party wall, and it is the responsibility of 43 and 45 to repair this wall.
Okay. Now there's an 8-foot spread between that wall and the new building?
That's correct.
Okay, well, so what we need to find out is that, what do you have to do to find out if the city believes it's a party wall? Okay, what do you have to do to find out if it's on the right location, or I don't know, whatever you do? What happens?
Right now, there's a permit that it was represented that a permit would be applied for the repair of 42, 43, and that would satisfy the concerns with the occupied property. But in the midst of that repair, it would be both property owners and their representation to come up with repairing the wall. If 43 wants to do the repairs in its entirety and add the repairs to the one side of 45, that's a monetary discussion between both property owners. But
Okay, is there a
essentially,
rule in the city about party walls that one person owns one side and one person owns the other side? Is there any rules on party walls?
it's just that there's a proviso in the code that if you're affecting an adjoining property and and it's a party wall, both owners are notified that work is to be done.
Okay, now did 45 at one time be up against that party wall before they did the revamping?
I would say that this wasn't a parking lot, or there was some sort of structure that was attached to this property at one time, which would make this a party wall.
Now, and this is Alex Barth again on behalf of the owner of 4245. So that if there was a property that had been adjacent to this, and I'm looking at from the photo you put up, Tom, the parging of that exterior wall, there was no demolition done by the current owners of 4245. There was no house there that was removed prior to this construction. This was a open air parking lot. So historically, I don't think anybody knows in this room if or when a house was there and when it was torn down. With regards to the party wall and any duty to provide lateral support, my understanding, and I think Mr. Hewitt, Mr. Gallagher can probably opine to this wall that is in question is not bulging towards 4245. The rear of this home at 4243 is sinking. So the wall itself is falling backwards into its own lot. It's not for lack of lateral support vis-a-vis 4243 and 4245, meaning I have to prop up your wall, it's falling into my property. The building is cracking in half and falling backwards. I'll liken it to the Titanic as it sank. It's cleaving and falling backwards. That repair is to be made from the rear of that property owner's property. I'm sure, yes, you can cause a repair to be done from an adjacent property owner if you want to go under the foundation, but that sagging, sinking, depression, whatever is causing that building to sag backwards, which it has been for some time, is solely confined to their property. It's not an issue of 4245.
Well, needless to say, we disagree with that assessment.
Question to Amy, as your structural engineer's hat. If you were to underpin the rear portion that is allegedly settling of 43, would that stabilize and arrest any further settlement, or is that settlement still vulnerable to any settlement that happens to the rear portion of the 43 building?
You'd have to find the source of what's causing it. If there's a water source, if there's a broken water line somewhere that is leaking water and causing erosion of the soil below grade, that you'd have to look for that first. My guess is that crack is happening where you have a basement that meets an area of the house that only has a crawl space. So the foundation's bottoms are not lined up and the back is sinking away. Yes, underpinning would help. It's probably a slow moving process. Underpinning would help. I do wonder if that crack opened up more for thermal reasons in November. You know, once things started getting cold, everything shrinks and it would open up that crack also.
This started way back in August, September.
So
Years ago. Actually, the violation on the property going back to 2002 that the inspector told us was from the crack. And if you look at Atlas, it's on there.
And stripping asphalt off a parking lot, allowing water to get into the soil is also going to exacerbate it.
And they're also working behind the rear property line of my client's property. This is the commercial development that's going on goes across several properties. So it's not just the next door lot, the work is also going on behind.
Well, we put a slab in for her, which should have, we put a whole new cement padding in for her, which should. help
But
with the
again,
water.
on 4245 and its adjacent parcels, which is an ongoing construction site of a multifamily dwelling, none of this work is immediately adjacent to this structure. Again, there is no underpinning, there is no foundation work immediately adjacent to her foundation in the rear, on the side, in the front. This property is, for all intents and purposes, these are separated detached structures. There is an 8 to 9 foot separation. The length of the depth of the lot running from Sansom going back towards Chestnut, going north towards Chestnut. And there is a rear yard separation in the back of her property. So there is no immediate construction, demolition, excavation work that is touching or adjoining her property.
So who owns that 8-foot property? Who owns that?
45.
Between the wall and the new house being built?
The owner of 45. That is a remainder portion of 4245 that has no construction on it right now. Basically a side yard.
Two questions for the owners of 45. What is anticipated for that 8-foot stretch as part of your development? What, when everything's completed, what will happen there? And to Amy's point, what precautions are being taken to make sure that there's no moisture or runoff that impacts the foundations of the shared party wall?
This is Forrest Passerin. So the area will be just a grassed, finished area. There's not going to be any structural improvement in there, and it will be graded appropriately. We have site drawings. It'll be graded appropriately to handle any runoff. We have a building that has been completely designed by professional engineers and architects that handles the runoff from those structures. So it's all been accounted for. There were no shortcuts taken here whatsoever.
And so the follow-up question, just to be sure we're understanding this, your approach to this is you're not intending to take any responsibility for anything related to alleviating the problem with the crack in the wall. Is that?
So let me just say that we want to discuss, these conditions, once you look at the photos, you're going to see that these conditions pre-existed us even buying this piece of property. It is so evident that her property is sinking to the back. You can see that she even put improvements on it that have since sunk. You can see how the improvements were installed that they even had to deal with the slope of the structure. So what we're saying is that no, we're not responsible for this.
Can I ask a question?
Yes, certainly.
It appears that grade was lowered on the site. I'm looking at Google Images, and it looks like grade got taken down about 3 feet. And it looks like formwork was set up at the back of her building to pour something or to temporarily shore something. Am I incorrect in that? Was grade taken down a couple feet in that parking lot?
This is Frank Hewitt. Yes, that's what I spoke of, was the when we began the excavation after the drilling process, we lowered that site about 3 feet. And
now you're at 45 because I just
45, yes, sir.
Okay, all right, go ahead.
We lowered the elevation of 45 about 3 feet or so. And that process of installing the lag wall is when we started to notice movement in the crack monitors. And just to put in perspective for you, ma'am, the crack monitors had moved 6 millimeters. It had moved 4 millimeters. It had moved 4 millimeters in that time frame. So the crack was open when we started the monitoring process, and the looking at the ground acceleration monitoring for while we were doing the deep foundations. The crack monitors were on there the entire time without movement. Additional movement began when we started that lagging wall excavation, and that lagging wall excavation resulted in a 4 millimeter move of the wall.
So do you know where the bottom of the foundation is at the back of her house? Did you potentially either undermine it or make so that it's susceptible to frost heaving?
We dug down that 3.5 feet and came to the top of a concrete structure that we believe is a monolithical footing of the original row house.
The original row house would not have had a concrete footing. I can see a stone wall in what was excavated. There would not be a concrete footing there. And if you came to the top of a footing, that means that house is now subjected to frost heave because it's not 3 feet below grade anymore.
Yeah.
That piece of concrete was discovered about 8 feet off of the party wall and about 3 to 4 feet down.
Okay, then that has nothing to do with that party wall foundation.
I have, just so we can all be clear in the understanding of this. Frank, when you're discussing your excavation where you made it down 3 feet, that is still 8 feet away from her party wall. Am I correct? Your removing of earth was where the foundation would be for the existing building, which is set back from the property line.
The building is 45's new building is about 8 feet back. The wall that you're seeing in those photos, the little bit of lagging wall that you're seeing, splits that difference. So that lagging wall, let's call it approximately 4 feet off of the.
And that's the shoring that's going down.
Yes.
The shoring that's going down for your excavation, which would be so you were not excavating down and hitting the foundation that is supporting her party wall.
Again, we excavated and found the top of a concrete entity and stopped excavating at that point. We did not do exploratory to see where it goes.
But to reaffirm your point earlier, it was still 4 feet away from her existing home.
May I ask a question at this point?
It's not taking place. It's not undermining. They're not excavating along the depth property line of her wall.
That is correct.
Yes.
Brian, is it appropriate for me to share screen and explain what I'm seeing on Google Images?
You may do so, yes.
Okay. Here's in April of 2024. It looks like you're setting up for construction. In August of 2024, here's where that pavement was. This has been taken down. This soil has been excavated down. They are right up against her wall. Again, if this is just a crawl space, that wall's not very deep. You can't tell me that this has not potentially undermined, subjected it to frost heave.
So
you are not 8 foot away there.
No, ma'am, we didn't say we were. We said we were 4 feet away.
No, 8 feet.
No,
the new structure is 8 feet. We're split the difference with the shoring. It's 4 feet.
What is this darkened substance I'm seeing?
So the area that building, and again, you'll see this if the engineer's report is presented. That building is a full basement.
All the way to the back?
Yes, all the way to the back. Right approximately where the gentleman is at the lagging wall bent over is the approximate location where we came across that piece of concrete. The exposure that you see on the adjacent to the parging or below the parging is the remnants of the parking lot that was there, the parking lot and its sub base. So it is down a little bit. Let's call it 1.5 feet or so. That was the sub base. We didn't excavate behind the wall. We're just doing a regular lagging wall installation there.
Okay, well, I feel that this was misrepresented in the beginning because
that is not a slab on grade.
There was absolutely soil removal there, and it did expose a wall that had been protected now to water infiltration. I'll stop there.
Okay, Tom, I got a question for you. Do you have any records of these, that 43 and 45 being, right next to each other on that wall?
You mean a structure on 40?
The structure, yeah.
I don't have that in front of me, no.
Google Images go back to 2007. There was no building there in 2007.
So I mean, for the department and for the purpose of the board, and I believe Brian could probably step in on it. We're not here today to discuss cause and effect. We're not here, that's property owner and property owner, and whether or not there's litigation between property owner and property owner, that's between each party. It's the department's belief that the party wall, the property at 4243, and the party wall that is shared with 4245 is eminently dangerous, and that a permit is needed to make this repair. It is imperative that the department ask on record that we receive an engineering report as to the property at 4243 being able to be occupied. With that said, we also are asking the board for a variance of 30 days to get the issued permit for the repair of this property. With that, the department will rest.
Okay.
I think at this
The
point it would be.
engineer's report that you're asking for from 43 or from 45 or from both?
We are asking for 43 because that property is occupied and we are worried about those occupants.
Yeah, and as a practical matter, the property owner next door, as well as the contractor, have disclaimed all responsibility to Ms. Fullwood, the owner of 4243.
Right.
So, I mean, at this point, it would be appropriate to hear, I think, from Mr. Motti as to what he's been doing and the observations he's made at the property and what his game plan is.
Yeah, if I could just add one last thing. Tom, do you feel in terms of 45 has been cited as well, I believe. Would it be appropriate to request an engineer's report from them?
We submitted one.
Hang on, let's just hear what I'm going to say. That specifically addresses whether the removal of the paving, soils, whatever, adjacent to the party wall as part of the construction of that property, the development of that property, have not contributed to the condition that has happened at the shared party wall.
So as a department, we wouldn't be, right now we have to deal with what's going on right now. It's not on us to say whether or not what caused it, how caused it, or any of that. It's the fact that the property has been declared as eminently dangerous by the department and it needs to be rectified. How that cost is recouped, that's not of the department's concern, but it's just that we're worried about the occupants of that property, the construction worker that's on that 4245, and the property itself and the general public.
Okay, you're telling me.
I think what Amy was suggesting there was that possibly the lowering of the site on 45 toward the rear it's no longer at least 3 feet, 3'6", whatever the requirement is, to the bottom of the footing at the party wall. And so it's a question of whether that's contributed to the situation or not. And that's only been because of activities by the owners of 45.
That ain't our reason to determine it. All we're saying, what our reason is this a party wall shared by both people, even though there's not a building up there now. And the city's telling us that this is a party wall.
Yes.
Each side is responsible for their side. I don't know what else my opinion, I don't know. I think it should be taken care of between the parties. Have you had discussions on what you can do or split anything or rectify this? Because both parties, from what we're being told from the cities, is responsible for each side of that wall.
I can tell you Ms. Fullwood's position is, one, it is a party wall that's the joint responsibility of the two property owners. Number two, that this house was stable as of the time this construction started at 45. And as admitted by, I believe it's Mr. Gallagher, that when the excavation work occurred next door, that is when the movement occurred. But notwithstanding the shared responsibility of the wall and the cause and effect with the cause of the crack, both of these adjoining entities, the owner and the contractor, disclaimed all responsibility to Ms. Fullwood. So Ms. Fullwood has retained an engineer and an architect to deal with the issues and also to serve as experts in litigation against the parties next door. And I think it would be appropriate. I think it would be appropriate to hear from Mr. Motti at this point as to his observations at the property, as well as what the game plan is going forward.
If you don't mind, I do believe that you've mischaracterized what Mr. Gallagher said. That crack existed at the time. We do not know what its movement was prior to that. It could be moving from January through the date we started monitoring, and then it just continued the 4 millimeters and we stopped. So it's a mischaracterization to say that the starting of the movement occurred concurrently with the time that the improvements were being performed on 45.
Additionally, there's testimony that stands that there was remediative work done in the house prior to our owning the property that shows them shimmering down doors to deal with the slants and everything as such. And if we get to the engineering report to get introduced into the testimony, we can show you the joists that are out of pocket and that are causing this thing from years of non maintenance, of deferred maintenance, that is causing this to occur. And you can't just simply bury your head in the sand and ignore your property's problems and hope for somebody else to take the blame for it.
But didn't you buy a property with a crack in a party wall?
So you have an existing property that has a parched party wall. It is a detached structure from our property. Under that analysis, if that's going to be the Department of Licenses and Inspections position, that every property owner has to take care of their neighbor's property at any time you purchase it, not just the idea that you owe an obligation of lateral support, but there is no statute or ordinance in the city of Philadelphia that requires me, just because there is an existing party wall, the purpose of which was built to pocket 2 joists together in 1885, that I have an obligation to maintain my neighbor's property. I have an obligation to parge the exterior wall possibly, but I don't have an obligation to make sure that my neighbor's property doesn't fall off to the rear of her home. There's an existing crack in the wall. I have no obligation to undergo repairs of my neighbor's property. If there is an ordinance in the city of Philadelphia, if there's a regulation or a building code that specifically states that an adjacent property owner has an absolute obligation to maintain their neighbor's property when they do not utilize the party wall. This is not all construction, as everybody knows, going forward in modern time involves building up to the property line. If I buy a property that exists prior to, and I buy the adjacent property, the idea that I am obligated to step in because my neighbor refuses or cannot afford to maintain it, you wouldn't be able to transfer a piece of property anywhere in this city. I mean, that obligation is so overwhelming and overbroad. And I will say, just again, to clarify for the record, and I believe that Mr. Coe's representation is absolutely incorrect. The contractor and owner of this property, upon noticing, after voluntarily monitoring, notified L&I of an existing crack that was widening. They brought it to the attention of the department when the inspector on site, who is typically on this project, was not available. They raised it to the next level so the immediate operator, the head of the district, could come out and view the issue. Immediately after that review, the contractor and the owner of 4245 engaged an expert, engaged an engineer. Those reports were immediately submitted with a timeline to L&I as soon as they were able to gain access to the adjacent property. This owner has done everything above and beyond what the department should be asking of contractors. They've done everything that a contractor is supposed to do in this city. To then expect them to have to pay to repair someone else's property, frankly, is somewhat is a burden that no one would take on. This property needs to be repaired from its own property. From the rear of its property, it needs someone to shore up its foundation, not their foundation.
Are they allowed to go over to your side of the party wall?
Sure, we'll give them an easement.
Okay.
If they want to come over and do whatever it is, we provided an opportunity so that we could have the stop work order on our property lifted. We provided means and methods that would need to be required by that owner to repair their property. Helical piles, grout injections, whatever that property owner has to do to shore them up. We provided a roadmap for it. It's been
Okay, what's it cost? What's it cost to fix this track? What you guys are in construction? Give me a rough idea.
Yeah, we've not engaged anybody to do it. We just provided the expert report. I don't know how much the expert charged to provide it. The engineering firm, Franjo, can opine to that. But
Does anybody know there 43 or 45? Does anybody know what that costs?
At this time, sir, I do not. I cannot give
Okay.
you even.
All right. Here's the deal.
Well,
We're going to caucus and then we'll be back. So the board members are going to caucus.
Hey, Wayne,
Yes.
I think Mr. Coe was suggesting that Mr. Mahdi, who is their expert, it'd be interesting to hear what he has to say about it.
Oh, fine. If anybody has something to say, go ahead.
Yeah, Mr. Mahdi, first of all, if you could identify who you are, what you've been doing at the property, and what your observations are on the issues that we've discussed. I'll turn it over to you.
Yes. Good afternoon, everyone. My responsibility on behalf of SE2 Engineering was to prepare an architectural plan and essentially describe.
You represent 43 or 45?
43.
Okay, got it.
That's correct.
Okay.
And to provide as much information as possible with regard to essentially presenting a make-safe plan. We certainly agree that the property is moving. I have not been privy to the report that the engineer from the for 45 made reference to. I would like to see that report. What we've done at this point is prepare a plan of the entire building. One of the things that was mentioned earlier was that the basement continue to the rear of the property. It does not. There's a crawl space, a considerable crawl space at the rear of 43. So the basement goes just beyond where that crack appears, probably about 10 feet or less to the rear. The space beyond that is crawl space. I think one thing I'd like to mention also is that there really needs to be some measure of cooperation, because even in our submission of a make-safe plan is going to require permission of the owners, or at least a letter from them that would comply with the monitoring plan that's required by the city. We have to submit a new construction survey and monitoring plan with our documents that would enable this to proceed to acquire a make-safe permit. I think at this point that's the most that I could offer. We definitely like to see the report that was prepared by the gentleman, the engineering firm that was consulted.
Let me ask you this: as far as the current, you've observed the property, your firm has observed it. As far as the safety of continuing to occupy the property?
Well, I'm inclined to believe or to agree with what the city's assessment is, and that is that it is imminently dangerous. It was classified as unsafe, and then in November, the department issued an additional violation closing the one for the unsafe condition and elevating it to an imminently dangerous condition. I would agree with that.
Okay.
And what, as far as the timeline of you submitting the permits, what is that?
Well, we'll have the plans probably completed in the coming week and be prepared to submit an application. We will need the permission of the, or at least a letter authorizing what we propose to do from the owners of 45. So if they're agreeing to do that, then in the coming week, we could probably submit an application for Make Safe.
Okay.
Assuming
Can you briefly describe what measures you're calling for, or is it premature until you?
It is premature, yes.
Okay, thanks.
Okay.
And if the board would like, we are prepared to share screen, just to put up the engineer's report that was submitted. It is as part of Eclipse. It was submitted by the engineer hired by Franjo.
Excellent. Thank you.
Just real quick, that was shared with Mr. Coe on October 16th. I'm happy to resend it, but if this is, we're talking about the Trans Systems October 3rd report.
Yes.
Yeah, that's been shared. So I'm sorry that Mr. Motti hasn't received it, but it should be in possession.
Thank you.
Yeah. All right.
My hand up.
If the board would like to see it, we're more than happy to share it and go through the photographs that were attached to it. That was an interior and exterior analysis done by a certified engineer.
I think it'll probably help. Yeah, I think it would give you some understanding.
All right, let's see it. Bring it up.
Mr. Hewitt, you had, this was submitted upon your request, correct? Or on behalf of Franjo?
Frank?
Frank?
Sorry, yes.
Yes. This is an October 3rd Trans Systems report. This was uploaded to L&I upon the request of the inspectors at that time who came out after the crack monitoring. It goes through the general observations of the building, exterior and interior observations, full height vertical crack in the existing wall, 25 feet from the rear of the building. Marking translates through the brick. Crack appears to have been previously patched. That's where the monitor was established. The crack propagates vertically to indicate that the rear of the building is settling downward, meaning to the rear. Interior observations also included floor and walls in the rear portion of the property where the crack is located. The finishes, meaning the meeting of floor and ceilings, are cracking where the rear of the property is sagging. I guess you would put it that way. And we'll see in the photos at the end, there's actually where they did a cut through into the plaster to see the exact location of the crack from the interior at the roof line. The framing, obviously, in a structure of this age, since it is not with ledger boards, is pocketed, so it's not positively tied. And I think, as you will see in the pictures as well, they're not fully pocketed anymore. So I think if you just want to go through, and that's the summary of the analysis, significant subsurface movement has been occurring for some time. Rear portion is settling, interior walls and floors, and their recommendation was lateral wall bracing at the rear, vacating until repairs can be made. Foundation is unstable, and they were talking about helical piles and grout injection, I believe, was what was proposed, would be a solution to that. If you go down to the photographs, similar to what the city has proposed, that's the front of the property. There is the rear along the shoring line. with the crack. Again, I don't know, Brian, can you zoom in to see if we can zoom in on?
Yeah, which one? Photo one.
The left, photo 2.
Photo two.
So that is the crack, that is the shoring wall that was installed there. The grading and movement, the excavation of the foundation is obviously to the left of this photograph on 4245. The vertical crack there going down, let's see. You can see the secondary crack in the rear towards, I guess, what is that? Chestnut. Yeah, the chestnut, that little outcropping wall, there's a secondary crack at that location in the same direction of the sag. Here's the rear of the property. Can you zoom in on that as well? Looking at the rear of this property, you can see at the time that this is existing improvements. The shape of the roof line itself is indicative of the fact that that sag has been there in a while, because the millwork around the exterior rear door has been cut and trimmed, as has the siding, to show that existing sag. That's the door itself has a full height trim at the top on the left and is barely trim on the right, same as for the siding itself. So that's indicative of a pre-existing condition that's been there for some time when that work was done. I don't know when that exterior work was done. If you go down further from here, I believe it goes into the interior of the structure, showing the existing cracking along the interior walls at the rear of the property, both vertically and horizontally throughout the rear. We have no idea what this property looked like prior to going in here. This was our first foray, obviously, into the property. That is the cut that was made in photo 16 through the plaster. And you can see the light. This is exactly at the point where the existing vertical crack runs to the roof line. You can see light through there at the very top of the crack at the roof line. And then if you scan further down, you can see what is evidence of displaced joists that have come out of their pocket. Again, this is existing conditions, but that is not a fully seated joist. And then is there anything after that? What's the last one that just shows further sag as the rear drops off? So this was done at the beginning of October after consent was given to gain access for the engineer engaged by Franjo. And this report was submitted and has, I guess, been circulated to Mr. Coe, but is also available for the department on the Atlas system, or sorry, the Eclipse system.
Was the sheathing and shoring designed?
Frank?
Yes.
So
I apologize for the lag in response. We're next to a train track, so we mute by habit, so it takes me a second, sorry.
So an engineer designed the sheathing and shoring?
Yes.
Okay. All right, Wayne, do you want to caucus?
Yes, I do. Okay. All right. Okay. 1 second here. All right. Here's our decision for 43 and 45. You got 30 days to make safe, to get a make safe permit before you start the work. Also, the 3 foot of, what is it, 3.5 feet of coverage in the back, Amy, that was dug up?
The rear foundations have to have at least 3 foot cover of earth to protect them from frost heave.
Okay, that's what we need.
That
And,
is-
so you guys gotta work it out. You've got 30 days to get a make safe permit. It's on both of you, 43 and 45.
Just to clarify, 30 days to apply for a make safe permit.
30 days to
Want to have it in the
apply,
system.
right. Okay, that's it, guys. Thank you.
Thank you.
All right, guys.
Thank you.
Thanks. Thank you.
Guys.
Excuse me, Ms. Rivera, this is the reporter. Could I ask you to clarify the word that comes after the term frost? I'm just missing that. Frost?
Heave, H-E-A-V-E.
Heaze?
V as in Victor, E.
Frost heave.
Correct.
Thank you. I wasn't hearing that clearly. Thank you.
All right. Okay. Next case. 501 North 64th Street. Who's here from 501 North 64th Street?
Rebecca Brathwaite.
Rebecca?
Yes.
Okay. Are you going to be the only one testifying?
Yes.
Are you a lawyer?
Excuse me?
Are you a lawyer?
No.
Okay. Please raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth.
Yes.
Okay. Tom? Tom? Okay, please raise your right hand. Swear to tell the truth, the whole truth, nothing but the truth. Tom?
Yes.
Okay. All right, I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted Agnus, board member.
Ryan McSherry, board counsel.
I'm Matthew Wojcik, LNI supervisor.
Philip Motto, Boards Administration.
Okay, Phil, could you read that into the record, please?
Yes, sir. MI 2022-004244 for the property located at 501 North 64th Street. Rebecca Brathwaite is the appellant. She's present in the room.
Okay, Tom, you want to tell us a little bit about this project?
I'm going to share my screen, but basically this was already heard by the board, but it was continued for the appellant to make contact with the adjoining property, as it appears that this involves a rear detached garage that spans the two parcels, which would be 501 and 503 North 64th Street. So basically it's this is a continuation. And with that said, I'm going to turn it over to the appellant. It's our belief that a permit needs to be obtained. We would be willing to give 60 as far as even 90 days to get that permit for the repair of the property or the demolition of that garage.
Okay. All right. Rebecca, you want to tell us your part?
I have been trying to get in touch with the adjoining property owner and I have not been able to. I sent a letter, the letter, I can't remember the term I'm looking for, letter. It came back. I also went. Yes, return to sender, right. I was given the address of where the person lived. I went there. I was not able to get anyone to answer the door. I went there on more than one occasion. I cannot get a hold of the person that owns. I don't have a phone number. I have no way to get in touch with the person that owns that property.
Okay. What does she do? What does Rebecca do? Because she can't get a hold of these people.
I am willing to do I'm willing to work with them to do whatever needs to get done. It's just that I cannot get in touch with this person.
So I can't tell the appellant any legal advice, but at this point, the appeal isn't for, the appeal is asking for additional time. She's made efforts to that.
Yeah.
It would be my recommendation to the board to deny the petition, and then the department would seek enforcement against both property owners and spur enforcement that way. And then that way, both owners could come into the Court of Common Pleas and explain their situation to the presiding judge at that time.
I have a question. Can I ask a question?
Yes, yes.
What if
absolutely.
I show up and then, I'm willing to show up. I'll be there, but what if the other person is still not there? I just don't know how long and like, what's the, if the person is not showing up and if I don't know what to do.
So to the appellant, I don't wear the black robe. That's the easiest way I can explain it. But at the end of the day, the department would be asking for a demolition of the property. And then
Of the entire property or just the garage?
no, just the garage. We wouldn't, no, the violation is for the garage and the garage only. So we would be asking for a demolition of that garage, and we would send the invoice to both parties in its entirety.
So here's my next question. If
Go
you
ahead.
if you guys do the demolition on the
right.
garage, so you said the bill would be split between two parties. I am only responsible for my half, right?
Yes.
I would never be responsible for the entire half.
You would, so we, normally the way the bidding process would go would be, we would have at least 3 of our demolition contractors that are on the master demolition program come out and take a look and see the conditions. They would submit their bid. Their bid would be for both parcels. And then you would be, it would be split, and then you would be sent the invoice for just your portion.
Okay. Do I get a choice of if I want to do it myself or if you guys do it?
Well, considering that this is again on both property lines, you and your own neighbor would be given the opportunity to pull a permit equally, and how you guys do that. But essentially it would be the department basically asking for the authority to go on both properties and do the site improvement.
Well, then we still run into the same problem because I still can't get in touch with him to even plan to do anything anyway. So
That's
it still
why I'm
comes back to the
saying.
same
So-
problem.
I
So
would
to-
suggest when you go to court, if you show up and they don't, it may not end up being split 50-50. So I think it's.
That's what I was gonna say.
Yeah,
Say that
I
again.
agree.
Can you repeat that and clarify that for me, please?
I'm saying that if it does go to court and you show
Yeah.
up and the other party, your neighbor does not, that I would hope that the judge would see that you have made every effort to resolve this, and they would not split the responsibility 50-50. I obviously have no.
We don't have anything, everybody, but what I would say to them, I would say, look, numerous times I took my time, my effort to go to their house, send them letters, do this,
Yep.
do that. And now I come to court and they're not here. I took a day off. I want to see all that time and effort subtracted from their half of the bill. This is what drives me crazy, and it ain't fair for somebody wanting to get something done when the other
Yeah.
person don't even answer.
He does not. I have no way to get into. I've tried. I have no problem.
I know,
I want to
I
get it
know.
resolved. I want to
know.
get it resolved. There was a tree in the back of the house. I cut the tree down. I took that responsibility upon myself and I cut the tree down because it was pressing on the garage. I've done everything, I'm willing to do whatever it takes to resolve this problem so we
I
can
can
move
see
forward.
I can see you are, and it ain't fair. I really, it's not fair. When somebody can just ignore anything and get away with everything. It drives me crazy.
Tom,
But-
the neighboring property also has a violation, correct?
They do.
Yes.
Okay, I mean, I'm looking on Google, their roof is covered in greenery.
Mhm.
So-
Yeah, they have a
But-
designation of unsafe for the garage as well.
Okay,
And
But the
Rebecca,
thing about it
I
is-
would keep a count of my time.
Yeah, yeah.
What I've done, what letters I wrote, everything, I keep account of that and say to the judge, this is my time. This is what I put out. This is what I had to take off work. This is where I had to come to, okay? And I like to have that subtracted from the 50% that I have to pay. And
Okay.
it goes on the other person because they're ignorant and they won't come in and face up to the issues that they have to face up. They should be penalized.
Thank you. I have a
And you
question. Was
can
he
mention
notified
that
about
the
this
Board of
meeting?
Building Standards Chairman recommended that. What for-
I will,
that
I
and
will.
50 cents to get you a cup of coffee, but you can certainly say I said that.
I will. Thank you.
I
Okay.
don't know if the owner was notified of this hearing, as he's not a party to this matter. It does involve it, but he didn't file an appeal. He or she did not file an appeal. If there was, we would have scheduled it at the same time.
Okay.
Okay.
Fine.
So
So,
to my representation to the board is to deny the appeal or to deny the variance, and then we move on with whatever line of
Okay.
enforcement that we can.
okay. And then we
Okay.
go from there. Okay, Rebecca?
All right. All right,
so
thank
we're gonna
you.
deny that. Okay, you're welcome, you're welcome.
All right,
So
enjoy.
to be clear, are we denying and giving 90 days, Tom?
No, I would deny so that we could move on, because if you
So they can
grant,
move on with it.
if you grant the timeframe, then we have to give the appellant the 90 or whatever the days is to get the permit or to meet that variance, and then that buys more additional time. So to me, it would be deny it, and then we can move right into doing what we
Common
need
pleas.
for compliance.
Okay, fine, good.
Okay.
All right, Rebecca, good luck.
Yeah, thank you. And if I do happen to get in touch with him, then I will let you guys know in the
Let us
meantime.
know. Yeah, okay.
I will.
Sure. Okay,
Thank
thanks,
you.
Rebecca. Bye-bye.
All right, enjoy your holidays. Bye-bye.
You too now.
Yeah.
Thanks.
You know, this is really gets me. When someone does things right and another person don't care, don't even say, and something should be done. I mean, all the time this woman is putting out, okay? And the other person could give a heck. They could care less about her and her time because evidently her time's more important than her time. It's not fair. And something has to be done about stuff like that. Ryan, you're a lawyer. You got to come up with something. I'm not. I'm just a construction worker. Okay, next case. Ingersoll Street. Who's here from Ingersoll Street?
I am Lori
Are
Chambers.
you Lori?
Yes, yes, Your
Hey,
Honor. Yes,
Lori,
sir.
how you doing?
I'm doing great. How are you?
Good. You're going to be testifying. Is there anybody else going to be testifying?
No, there will not.
Okay. Laura, could you raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, Tom? Tommy? Go, Tom. Where's he at? Tom, you hear me?
I hear you.
Okay, raise your
Camera
right hand,
pick back
swear to
up.
tell the
There you
truth,
are.
the whole truth, nothing but the truth.
Yes.
Okay, I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
Ryan Sherry, board counsel.
I'm Matthew Wojcik, LNI supervisor.
Philip Motto, Boards Administration.
Bill, could you read that into the record, please?
Yes, this is MI 2024-007-204 for the property at 2447 Ingersoll Street. Lori Chambers is the appellant, and she's present in the room.
Okay, Tom, could you tell us a little bit about this case?
So I'm going to actually do a little opening statement, but then defer to the appellant as the city did not make the appeal, but I do ask the board to address the matter first of a untimely filing, as this matter was where the violation was issued and with notices being sent in on October 1st of 2024, following a litigation in the Court of Common Pleas by way of a conservatorship that was filed by the appellant. With that, the appellant did know of the violation and that they are working on obtaining the permit for the repair of the property. So in my belief that this is an untimely filing, and that should be addressed before granting or denying a variance.
What do you mean an untimely filing? Tell me, what's that?
So this appeal was filed on December 3rd of 2024.
Okay.
The notice of the property being in violation was sent out October 1st, or I'm sorry, was sent out August 27th of 2024. So with that notice being sent out at the end of August, there were more than a few months to apply for an appeal to this board. But in fact, there was other litigation that was subject by way of a conservatorship filed by the appellant. So it's the department's belief that this is an untimely filing to the board. The appellant knows that they have to get a permit for the repair of the property, and they should do so accordingly.
So could I just clear things up? Lori Chambers is a conservator for the property. She's not the owner.
It is my understanding that Ms. Chambers is an heir to the owner and has filed a conservatorship to take control of the property by way of her representation, but Ms. Chambers could address that directly. But that's from what I understand.
Ms. Chambers, you want to tell us your side?
Yes, please. Good afternoon, everyone.
Hi.
Yes, I am an heir to the owner of the property by way of my father, who was, the owner of the property prior. The confusion that Mr. Robrowski, I hope I'm pronouncing your name correctly, or can I just call you Tom?
You can call me Tom. It works great for telemarketers. It's all good.
Okay, I'm sorry about that. All right, don't mean to butcher it. Okay, so Tom is halfway right. I'm not filing for conservatorship. I'm actually the heir who is the respondent to a conservatorship action taken on the property, for clarification. And the reason why the appeal had been filed late, he is correct that it was filed December 3rd. And that it was initially reissued August 28th of 2024. The reason why I hadn't appealed it is because I didn't know that I could qualify for a hearing. But I do have documentation that the reason why I didn't appeal it is because I was steadily fighting the imminent demolition of the home. And I have records showing that I had been in contact with the city solicitor and the code administration unit and the contractual services unit. And I would like to show a picture of the demolition notice. It's probably blurry to you guys.
Yeah, we got a rough idea.
So, Ms. Chambers, I can stipulate to that. We do know, and that's why the property is still standing. We know that what's going on with what you're dealing with. We understand that. You need to get the permit for the repair of the property. That's where we're at.
That is correct. That's correct, Tom. But yeah, I just wanted to explain. I was on the phone at LNI, built a very great relationship with everyone down there. And that was, I thought that I was appealing. So what they did was they reissued the violation as a result of me being able to stand down the demolition order. Because I had no clue, I had been communicating with LNI since the initial issuance of this violation, which was September of 23. So I had been in contact with my inspector, Joseph Carroll, and I just didn't understand why everything was progressing so quickly. And I was informed of everything else, but as far as equity court and bidding and things like that, I was scared to death. So I was in contact with everyone up to the city solicitor, didn't know that the appeal was something that I needed to do, like I said, until I went back to court and the judge initially or ultimately said, you have to appeal this because you've been trying to. And I was telling them I essentially went up there to appeal and I got turned around because it was in a conservatorship. So when I went to go talk to Debbie and went down there, let me see, I have that date. But nevertheless, it was within the appeal date. She turned me around and said, we've already talked to your lawyer, because at that point I had to call city council and get advocacy from them because, with all of the conservatorships and the Act 135s and the tangled titles, all of the free law services are at capacity. So I have been doing a lot of legwork, and that is why I'm here to finally appeal. But I'm sorry, that's a huge preface. I did engage the services of an engineer. And I am the one responsible for clearing the violation, and that's what I would like to share on the screen. And
well, I don't think you have to get that far. I just have one question for you, Ms. Chambers. What's the status of the court hearing? What's the status of the conservatorship? Is there a pending litigation, or is that resolved?
They did not win, so I'm still fighting. I'm still here. Thank you.
All right. So with that said, my petition is with the board. Can we have a ruling on hearing the matter as to a untimely filing, and then whatever, if you want to hear it, then we can move into my recommendation to the board.
Give me your recommendations.
90 days to get a permit.
I will allow
90
the
days to get a permit.
I allow the untimely filing.
I don't worry about that.
90 days to get the permit.
90 days to get your permit before you start working. Okay.
My contractor, or rather the engineer actually says that the permit may not be necessary. That was always what I stood on with the appeal. And I did, engage the services of a Pennsylvania engineer that kind of backs that. What I'm asking for is an easy permit. I would like to go down there and get an easy permit to continue to beautify the house. The house fell into, disrepair. My father passed away late in 2022. And it took a while to find somebody that I can trust that, had enough skills to really help me work on the house. And really a problem now is beautification. So if I could show you the engineer's letter, I paid that money to have the engineer come out, and he essentially said that it's not, we don't need a permit. We probably need an easy permit to do some aesthetic things.
So what I can do is I can give you my email address, Ms. Chambers. I can
Yes, sir.
recommend to the board to still go through with the variance of 90 days to get the permit. And if that engineer's report does in fact state the property is safe, then we would comply the unsafe designation on the property, because the violation that's issued is for a unsafe matter for the fracture and bulged wall. And it does order you to obtain the services of an engineer. So if you did that and the report doesn't illustrate the matter of making a repair, that it is in fact safe, then you could get your alteration permit once that unsafe designation is resolved.
Yeah, Tom, I assume that you can't get an easy permit until the make safe permit is resolved, as you say, right?
Correct.
Yeah.
And that'd be the engineer's report, right, Tom?
Yeah.
Okay.
So, Ms. Chambers, my email is Thomas.
All right, just one moment.
And just while you're doing that, it sounds like if you can resolve it sooner, you can get an easy report, an easy permit and move forward sooner. But we're still giving you 90 days to do it, the understanding
Or whatever.
your intent is to do it sooner.
So it's Thomas.Rybakowski, RYBA KOWSKI at Philip PHILA .gov, GOV. Make sure you put a period between Thomas and Rybakowski.
Okay, thank you very much.
Okay.
And just to clarify, when I say that they did not win, we do still have another status hearing, but status hearings are victories, because that means that they have not, succeeded in proving their case. This is what the case is hanging on. And as I said, I essentially did everything that is supposed to be done. And, I believe that everything is, above board.
Yeah, just email me that report and then I'll let you know what the finding of the department is.
Okay, thank you very much.
Good luck, Lori. Take it easy, all right?
All right, thank you. You too, Mr. Miller.
All right.
Bye-bye.
Okay. 323 Ontario Street. Who's here from Ontario Street? Let me see, Ontario Street. Ortega? Mr. Ortega? I think you're on mute. I can't hear you. Or am I on mute?
Yes, I am.
Oh, okay. Are you the only one testifying today?
No, sir. I have my son and my husband here.
Okay. I'm gonna have to swear all three is in individually. Okay. Mrs. Ortega, could you please raise your right hand? Swear to tell the truth, nothing but the truth?
Yes, sir.
Okay. Your grandson, your son? State your name.
Miguel Ortega Jr.
Okay, Miguel, can you please, you got the right hand raised, swear to tell the truth, nothing but the truth?
Yes.
Okay, and is that your grandson or your son?
My husband.
Oh, your husband. Oh, okay, so I can't see your hood. Okay, please raise your right and state your name.
Miguel Ortega.
Okay, please, swear to tell the truth, nothing but the truth?
Yes.
Okay.
Excuse me, sir. Could I have Mrs. Ortega's first name?
Oh.
Adelaida. A-D-E-L-A-I-D-A. Adelaida.
I'm sorry, that got a little garbled. Could you please repeat?
A-D-E-L-A-I-D-A.
I'll
Thank you.
tell it from the violation. It's ADELAIDA.
Okay,
Yeah.
okay,
Yes.
good. All right, Tom, could you please raise your right hand, swear to tell the truth, the whole truth, nothing but the truth?
Yes.
Okay, I'm Wayne Miller, board member.
Amy Rivera, board member.
Ted August, board member.
Brian McSherry, board counsel.
I'm Matthew Wojcik, LNI supervisor.
Philip Motto, Boards Administration.
Bill, could you read that into the record, please?
Yes, sir. This is MI 2024-007-215 for the property located at 323 East Ontario Street. Miguel Ortega Jr. is the appellant. He's present in the room.
Okay, Tom, you want to give us a little bit on the case, please?
Yes, so we have an unsafe designation against the property at 323 East Ontario Street in result to an emergency action that we were called out to the property in response to a fire that occurred in May of 2022. I'm a little confused because the violation dates back to May 13th of 2022 with a notice being mailed out on or around May 16th of 2022. And we did not have an appeal filed until November 1st of 2024. And that appeal is, it's the department's belief that that appeal was filed in response to the appellant receiving a final notice that the property was still in violation. My understanding is that a permit had been obtained back in July of 2022 for the removal of this of the rear addition that had been damaged and was actually an illegal structure. That permit was since expired by the department because the contractor failed to notify for inspections. That said, I'm asking the board that this matter should be dismissed for an untimely filing, in that the filing or the appeal did not take place until almost 2 years past the violation period, and also a permit was issued. So I'd like to hear whether or not the board will accept the late appeal, and then we'll carry on the merits of the case.
Okay. Ted, Amy, are we fine with the late appeal?
Let's hear what got done.
Yeah, Tom said he wasn't going to continue unless we make a decision on a late appeal. Right, Tom? Is that what you said?
Yes.
I think we should probably have something on the record from the appellant in response to Tom's argument with respect to the untimely filing.
Thank you.
Okay. Whomever's going to represent the case, Mr. or Mrs. Ortega, could you tell us why you did not file when the untimely filing of the appeal?
Okay, I'm more like translating to them. They're gonna explain it. I'm gonna explain them what you said in Spanish, because English is limited.
So unfortunately, I don't believe we'll be able to continue. We're gonna need the services of a professional interpreter. Unfortunately, you're not able to provide interpretation services. It's a due process issue. So unfortunately, at this time, we're gonna need to continue this hearing, and we'll order an interpreter for you.
Okay. That's
unfortunately we cannot continue or allow you to do that. We need to have a sworn court interpreter to do so.
Okay. We have to have a sworn interpreter from our side for you guys to be able to present your case, and we're going to continue the case to what our next meeting, Phil?
I believe January 9th.
January, we're gonna continue it to January 9th, postpone it until January 9th. Will we be sending anything else out to the Ortegas?
Yes, we will. We'll send the new notice out.
Can I
Okay,
ask
you
a
guys,
question?
you understand?
If Mr. Ortega is the applicant, can he just
I mean, he
appeal the case?
yes, but he can't provide it. So
He can't provide translation for other
He can't.
families.
He can't provide translation if Ms. Ortega is going to be acting as a witness. He can't be interpreting for her for our purposes of what she's representing.
Okay, so what we're gonna do is we're gonna continue the case to January 9th, and then you'll come back and we'll have an interpreter here to, because of the language barrier, okay?
And just to be clear, will it be a Spanish interpreter, if I may assume?
Yes.
Yes. Okay, all right, we'll see you tonight, okay?
Just a clarification, we're basically saying we will hear the case on the 9th. We're not, in terms of the, in terms of the first issue of whether we're allowing it to be heard, after the deadline. Is that
right, Brian?
Making that determination?
We hadn't gotten to that stage yet. We were going to hear testimony in response to Mr. Rybakelsi's argument as to timeliness. Yes.
Okay. All right. All right. We'll see you guys on the 9th.
Okay. Thank you.
Okay. Bye-bye.
Bye-bye.
Creo que terminan el 9.
Okay. Next case. 1 South Christopher Columbus Boulevard. Who's here from Christopher Columbus Boulevard?
I have all the appellants for our next cases still in the waiting room. I'll bring them
Bring
in
them
right
in.
now.
Bring him in.
For me, if I don't see it, enjoy. Have a great holiday.
You too, Tom.
You too, Tom. Thanks.
Have a good one, buddy.
You got it.
Hello. Can you hear me?
Yes, we can. Is everyone in, Tom or Phil?
Yes, sir. Everyone from the
Okay.
waiting room is joined.
Who's here from Christopher Columbus Boulevard? Can you tell me your names?
Yes, you have Philip Borst with Scunsy Borst International representing Delaware River Waterfront Corporation.
Okay, who else?
I'm Lizzie Woods with the Delaware River Waterfront Corporation.
Okay. Who else?
Yeah, Ari Miller and Shannon McLean with Hinge Collective as the design professionals.
Okay, Ari and Shannon. Okay. Anyone else?
No, sir.
Okay. Is there anybody lawyers for the clients?
No, sir. No lawyers.
Okay, so here's what we're gonna do. Phil, please raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Lindsay, please raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Okay. Ari, please raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Shannon, please raise your right hand, swear to tell the truth, nothing but the truth.
I do.
Okay. Okay, my name's Wayne Miller. I'm a board member.
Amy Rivera, board member.
Ed August, board member.
John Dimes, Fire Code.
Ryan McSherry, board counsel.
Matthew Wojcik, LNI supervisor.
Philip Motto, Boards Administration.
Okay, Phil, could you please read that into the record, please?
Yes, sir. This is going to encompass matters 7 and 8. First one
7
being
and 8.
MI 2024-007-147 for the property located at 1 South Christopher Columbus Boulevard. And matter number 8, which is MI 2024-007-148, also for the matter of 1 South Christopher Columbus Boulevard. Hinge Collective and Ari Miller are the appellants, and they're present in the room, sir.
Okay, whoever's going to present the case, please do.
Hello, everyone. Thank you for taking the time to meet with us. Ted, long time no see. How are you? So long story short, we've basically prepared the project with the Winterfest River Rink for the Independence Blue Cross River Rink down on Columbus Boulevard. And we've gone through L&I with all of the proper submissions. And we are ultimately requesting, we're humbly requesting a waiver for the need for foundations for the tent structures that are up. We've placed a number of other structures on the facility, on the site. Everything has been done to code. And the tent structures have always stood alone, stood on their own. We did bring in a new tent structure, but they've always stood on their own and are anchored sufficiently. And we were just requesting, asking for your forgiveness and waiving the need for structural foundations for the tent structures themselves.
Matthew, what do you think?
The exact variance is for says not providing anchorage or foundations and for not providing a geotechnical investigation report. It's the same refusals on both.
Okay. Tell me a geotechnical, I don't know what that is. Can you explain that to me?
So we actually did turn in a geotechnical. I think maybe how it got sent over from L&I, we did provide one. So that is in the system. So our understanding, and I apologize for my ignorance, but my understanding was that the refusal that came was only really for a concrete foundation. But a geotechnical report, sir, just tells us what the soil conditions are beneath. That's what it does to answer your question specifically. We did provide an older one and a younger one, so they were in the system.
Bill-
Sorry, go ahead.
I was just gonna clarify, there is another structure on the site that did require a foundation, so we provided the geotechnical report for that foundation, which went through the system. Because we were seeking the variance for the tent structures foundations, it covers both things. We would not provide a geotechnical report because we didn't have a foundation for the tents. They sort of are linked together. Phil, sorry, I was just.
No, it's perfectly stated, but but the report we provided is within.
Would have covered this as well.
It's well within feet distance of where the foundations are, where the other one was.
Are these temporary structures?
Yeah, so they are. So our appeal is for a 5-year period. So the river rink is going to be relocated. So these tents are up. We do take them down to clean them periodically, but in all reality, they're intended to stay up for 5 years. And that's what this appeal is for.
And in the summer, the rink gets used for roller skating?
Yes, ma'am.
Okay. Do you have pictures of the tents?
We do. We have design pictures. We can also, I'm sure some of us have photos. We can pull those up as well. Would you like to see Hinge's design, or would you like to see the actual usage photographs?
Both.
Both. Okay. So, all right, if you don't mind, can you pull up the layout? And Lizzie, do you have photographs by chance? Awesome. Sorry.
We
had
have
everything teed up. I didn't know we were going to show photos. My apologies.
Hinge prepared site plans. The manufacturers for the tents provided structural drawings and architectural drawings, which were stamped by a Pennsylvania registered engineer. And those are the drawings that we have. They're not particularly illustrative or give you a whole lot of information about what the tents look like, but they do provide all the required information relative to the structural stability, meeting the code.
Yeah, just bring them up if you can, Ari.
I am working. There we go. So there are two tents. One is called. Can you see this, by the way?
Yes.
Okay. One is called the Lodge, and the other is the Arcade/Skate House. So one is located here. This is the new tent, and then the Lodge tent is the one that has been relocated.
Got it.
And sorry for the trouble, Lizzie. Do you happen to have the pretty pictures?
I do.
Do those drawings show how they're holding them down?
No, but this full set. This is actually even just excerpts from the structural drawings. This does have the full level of detail for structural compliance. And these are all in the Eclipse system if you want to review them in more detail.
Yeah, please forgive me if we're not presenting as clean as you need for your time frame.
No, and some of these tents have been up for a while already.
Yes, ma'am. The lodge tent existed further south for the river rink for the past 12 years.
Mhm.
We relocated it to the new position, and then the Arcade Skate House is a new tent that we purchased and that we put up
From the same manufacturer.
from the exact same manufacturer, same spec, everything.
Were other variances required when these were, put up initially?
No, sir.
Okay.
No, sir. It's just that I think with this go around, when we went in for L&I's approval, they wanted to kind of clean it up a little, and they guided us through the process, and we spent about 8 to 9 months going through the approval process. And we got through. We got all the approvals. We were able to open, but we're opened currently under a temporary because of this appeal. So
Matthew, did you review this?
No.
Who did?
Which one? Because there's
Well-
like several applications, so I'll have to check.
Who'd you guys, who'd you review it with?
So, Ari, do you remember the contacts you had? So we
Shakir Cohen was one of the reviewers. I think that Shakir Cohen was the reviewer for this particular submission. Yes.
Yeah.
For this particular application.
For the two being
Matthew,
appealed
you have
today.
any notes on that?
Right. Let's see here. So just the two being like heard today. That's what you mean, right?
That's all I'm hearing,
Okay.
because I don't know anything else.
I think everything else was approved and
Everything else
finalized.
is approved.
Again, my apologies if this isn't as organized as it's supposed to be.
That's all right, we're disorganized anyway. Go ahead, Matt, let us hear.
Trying to find all the let's see here, plans required. Trying to see
And
here.
what's the duration that these will be put up for, or will they stay up for the 5 years?
So they'll be up for the 5 years. We do take the roofs off to clean them and just, make sure that they're sound, and we put them back up.
So just to clarify, we operate the winter rink from November to March every year. And in the shoulder seasons, we take them off, and then we open the summer rink from late May through September. So there are shoulder months during which the site is not in use, at which time we take down the tents take down the roofs for cleaning.
Yeah, and then when the cap project finishes, this entire site is going to relocate on top of the cap when the I-95 cap project ends. We're just holding the fort down and for the
Right.
city
So the
revenue.
new I-95 project that you see being built, if you drive down 95 right now, that's a new 12-acre park. That's where our ice skating rink will be housed in a permanent location with a permanent building. So this was really a temporary relocation of our facility to hold us over while construction was going on. And we'd like to just get the blanket approval for that 5-year period so that we can, just move forward with that rather than going back every year.
And so at that point, you'll be asking for a permanent permit for.
A permanent building
not another
permit.
5
Yeah,
years.
they'll-
Yes, exactly.
there'll be
This will be, we're
Yeah.
going through the full, that's a full built building, not a tent
Oh.
structure.
That'll only take 2 weeks to build, 12 days.
Right.
So you
What do
showed.
you got, Matt?
Not
Matthew,
there wasn't
come up
much.
with-
There wasn't
Huh?
much here, just beyond just like they need to provide these things and they're not
Okay.
being provided, and that's kind of it. As far as the soils report is concerned, there was one soils report submitted under one of the many applications, CP 2024-004508. That's the only one it was submitted to.
All right, can you pull up the last one so that we can give it to them now?
I don't think that's going to apply. I'm just curious how these are anchored down. You showed a picture of calculations and they showed a post with a base plate on it. Is that base plate anchored to asphalt? Is it anchored to anything?
Yes, I can answer that as well. They're anchored using these 3.5-foot spikes that also meet all of the wind load requirements when in a hard or dense surface, and they're anchored at every structural rib.
So every rib of the frame has a column. That column has a base plate. That base plate has straps that bring down to its to the spike, and the spike is anchored in. It's like you said, 3.5 foot. Ari.
Yep.
So if you can go back to that image, that might help. So
There's
then,
there's like a double spike system here.
Oh, and there's almost like guy wires also.
Correct.
Okay.
yes.
Yeah, it's in this fashion here.
So the anchor plates are at the base of the column. If you look down at the lower left image where you see the tent,
Yes.
the anchor base that you saw, that plate resides at the base of the column. And then in addition to that is the spike and strapping that goes from the top of the column.
Sorry, I was trying to zoom in there.
And when you were kind of zooming through it, it looked like, I thought I saw like 85-mile-an-hour winds, sort of maximum. Is that?
Hold on, I will.
Designed for?
The pull-out capacity is 2,500 pounds in a hard or dense surface, which we would definitely qualify this as, because it's going directly into asphalt.
That's only 2 inches worth of the 3 feet, but anyway.
And how much is the wind? What you say the wind's up to 85 mile an hour?
Yeah, what's in his calculations? Somewhere in the front end, it should say the wind speed
Where?
that they designed for.
Road diagrams.
Oh, the wind. Oh, are you talking about for the anchoring or for the structure itself?
The whole structure. I mean, it will
So
all
it don't blow away.
funnel down to the anchoring, but I'm just curious if they designed it for the proper wind speeds.
Yeah.
The
Uplift. Yeah.
yeah, the structure is designed for the proper wind speeds. The anchoring, but the anchoring would be related to the uplift issue. Yeah. And if they are 2,500 per anchor, then we're definitely exceeding that.
Okay, I'm just looking for the wind speed at this point. It should be somewhere in the beginning.
Yes. So if we go to wind speed. There it is, the wind loads.
Basic wind speed is 115. Okay, that's what I was
Yeah.
looking for.
Yeah.
All right, we good with it?
No, I think we should caucus.
Okay, all right. Let's caucus.
Okay, sorry for the trouble, everyone.
No problem.
That's what we're here for.
Oh, they're back.
Okay. Is in the report, is there anything in there that says, taking the settlement issue into concern with the spikes and everything going through about 2 inches of blacktop?
When you say concern, is if there's gonna be something in the way or?
No, the settlement of the blacktop, right, Aim?
Right. The report that you showed, from what I could see, addressed wind loads and uplift. But your base plates are sitting on asphalt. You potentially have a snow load on them. Like, you potentially have a building load on a base plate that's sitting on asphalt. Has that been signed off on by the engineer in the report?
Are you referring to a geotech? That would relate to a geotech
No,
report.
not, I'm talking about a base plate sitting on asphalt. A base plate that's supposed to be sitting on concrete is sitting on asphalt. Asphalt deforms, especially in the summer, it will deform. Has that been taken into consideration? There's going to be settlement issues with the structure, potentially. If that's all been signed off on, I'm okay with this variance, or if you can get a sign off on all that.
I can't speak formally to it. I'd have to analyze so I don't know if we can do all that here together. Can we open up their shop drawings and their stamped, Ari? And see if they discuss snow load in there? I'd hate to leave the group and not have at least look at it together.
I don't think we're here to review
Oh, I'm sorry. I didn't mean.
all of that.
And Phil, we would be fine.
I lost you, Ted. Sorry, I can't hear you.
fine with, if it's not already addressed.
Ted, you're breaking
Can't hear
up.
you, Ted.
They can't hear a thing.
So these tents, for example, they're prefabricated tents that get used all the time in different locations throughout the city. We're just using them for the purposes for these seasonal events.
All right, it says ground snow load is not applicable. Yes, it is. But thing's gonna have snow on it.
So if we got the engineer to account for the snow load and any settlement, I think this is where Ted was going. If we reviewed this with the engineer and said, does your analysis still hold, taking into account snow load and any settlement
On asphalt,
on asphalt,
yes,
we could share that information?
yes.
Yes.
Okay.
And where do we share that? Do we submit that into Eclipse? And then how do we get back to this council?
I think Matthew has to answer that.
Yeah, Matt, what do you want? It sent to you or sent to somebody else? And you don't have to come back in again.
Ted just messaged everyone saying that it could be reviewed administratively.
Yeah, you don't have to come back in. Just if it's the okay from the engineer, then we're fine.
Okay.
But I think we need a resubmission because again, this said snow load is not applicable. This is up all through the winter. I think snow load is applicable.
Yeah, again, forgive my ignorance. That's why I wanted to look at it. I wasn't sure what it said. I didn't know if it addressed snow or not properly. So, so we would submit it to Mr. Matthew, or do we submit it just in Eclipse?
No, just submit it to, send it to somebody so they have it, so it don't get lost.
You can
Okay,
send
and
it to
then-
me first,
Yeah,
Okay.
and then
and
I
we-
can send it to the examiner so that they can look
Good.
at it, or I'll
Good.
just look at it.
that's good.
Okay, and then they would respond, and that would be our clearance if acceptable. Okay.
Yes.
And thank you all for your patience.
All right, guys, good luck.
So this is essentially continued, correct?
Yes.
Yeah.
Yeah, Ryan, is that, yeah, until you get that information, then we're fine.
Was
All
there
right.
any other concerns, or is this it? If we can address the
That's it.
speed load, we turn it into Matthew, he gets an answer, and we're good to go?
Yes.
That's amazing. Thank you so
Thank
much.
you so much, everyone.
All right, guys, good luck.
Thank
Bye.
you.
Okie dokie.
Thank you.
All right. What do we got here? We have the next one. Front Street, right? Reconsideration?
Yeah.
Is anybody here from Front Street?
Yes,
Okay, are you Gabriel?
I am.
Okay, hi Gabriel, how you doing? All right, we'll get
Hi,
started. We'll go back over it again, all right? Gabriel, you're gonna be testifying. Can you please raise your right hand? Swear to tell the truth, nothing but the truth?
I do.
Okay, all right, I'm Wayne Miller, board member.
Amy Rivera, board member.
I believe board member August is still having issues with
Yeah,
his audio.
Ted's a board
I-
member.
Yeah, Ted, I don't know if you want to maybe back out and come back into the hearing, or I don't know if Phil has any recommendations.
Give me
Okay,
one
go ahead.
second. I'll try to bring them back in.
Okay, thank you.
Ted?
Yeah, can you hear me now?
Yes.
We can, yes, sir.
I don't know, I didn't do anything other than leave the meeting and it put me right
Okay,
back.
you're good.
Okay.
John Dimes, Fire Code.
What do you say, Dimes?
Hey, Wayne.
All
Ryan
right.
Sherry, board counsel.
I'm Matthew Woods,
Okay.
Nice supervisor.
Philip Motto, Boards Administration.
Okay, Phil, could you read it into the record, please?
Yes, sir. This is MI 2024-005-912 for the property located at 336 North Front Street. Gabriel Deck is the appellant. He's present in the room, sir.
Okay, Gabriel, go ahead, pal.
Okay, and Roy, who's the owner of the project, I believe is also on the call.
Okay, Roy, you're gonna be testifying?
Sure.
Okay, please raise your right hand, swear to tell the truth, nothing but the truth?
Yes.
Okay, go ahead, Gabriel.
All right, I'll share my screen here. This is the second
Sure.
time you guys are seeing this this project, so bear with me 1 second. Okay, can you see my screen?
Yes.
Okay, so 336 North Front Street. This is the property where we were asking for short-term accommodations. We were required to have a second means of egress. It is a 3-story plus mezzanine structure. The drawings on the screen are actually what we've revised since meeting with you guys. If you recall, we had a single exit building arrangement with an interior stair tower, and we were required to have a second means of egress on both the second and third floors. And we had discussed incorporating a spiral staircase off the back of the building, which we are working into the plans right now. During the hearing, it was my understanding that it was acceptable for this spiral staircase to lead into the Delaware Expressway right-of-way, which is behind the property, and make its way out to the adjacent right-of-ways at Callowhill Street or Front Street. The refusal, or sorry, you guys granted the variances, and the letter that was provided actually required us to provide an easement through the property to the south of us, which I think contradicted what was discussed in the hearing, and we're here to kind of provide more supplemental documentation for what the Delaware Expressway right-of-way looks like in reality back there, as it does currently provide light and air and usable space and seemingly egress for a number of other buildings that are adjacent on the block. So we've provided a supplemental documentation package just to help orient everybody with what's going on here. So we are the property in yellow. The Delaware Expressway is on the left-hand side, Front Street, and then Callowhill Street at the top of the page. Everything in red is the Delaware Expressway right-of-way. So our property, along with all the other properties, kind of back up to it. And so what we're hoping to accomplish is the second means of egress, allowing us to just utilize this expressway right-of-way space behind the property. So to kind of get right into it, here are some photos of the property. So if you remember, we are the property that's up against the billboard property. This is where you wanted us to provide an easement. We're not able to obtain that easement from the adjacent owner of this billboard property, but that is the only thing that sits on the property left to us as well. The behind in the Delaware Expressway right of way, these are actual photos right behind our property. So right, you can see in the middle photo is actually the foundation of our property on the right hand side, and then there's kind of a fence and gated condition. And then you can kind of see the adjacent properties next to us have windows. Here's a better photo. Windows, doors, and the expressway right-of-way is on the backs of these buildings. So we would be asking for a situation in kind with what's there right now. There's a number of other photos in the packet that was sent along that show the vantage point from other areas back here. So this is kind of standing beyond in that right-of-way area. In the background is a gate that leads to the back of our property, which is kind of right back here as well. All this is to say that there's a lot of ample space back there, and that all of this space does then dump you back out onto Callowhill Street at the top of the screen, and then also back onto Front Street at the bottom of the screen. And there's, you know, just open vacant land that is part of the Delaware Expressway right-of-way right behind us. And then we're hoping to utilize that as well for the second means of egress that we've accommodated into the structure.
Is that gate that you showed always open, or is that ever closed off? So
the gate that is in the photos, I can't say if it's always open or closed, but even if it
It's
were-
always open. A lot of the residents take their dogs back there.
And then
So
Roy-
Gabe, I'm confused. The buildings that are back there, are the back walls their property line?
It seems to be that way, like when the Delaware Expressway right-of-way was created, after these buildings were constructed, it seems as though the lines were struck right at the back of the buildings for the new property lines.
Do any of them have back doors into that area?
Yes, like you can see in this photo, there is a door
Okay.
there. And Roy, I believe you have another building on this property that maybe has a door going back there?
Yes, 342 front.
And it looks like the neighbor next door took the liberty of that fence and grabbing some of that land?
Maybe, I can't.
Maybe,
speak
okay.
for- Yeah.
Majority of the properties on the block, I mean, all of them have doors back there.
Yeah, and here's a few more photos to kind of show just the aerial condition and that property line. If you look on Atlas, you can kind of see the expressway line just along the backs of the properties.
Yeah, I mean, I think our concern was it's fine as long as it's always maintained as a open air, area that gets you to either street and is not closed off. And without any kind of, but what would happen if they were to just fence it off and make that not, in spite of people's back doors, you can't go out there. And that's why, I think that's why we were looking for, some kind of, easement or letter of agreement, providing sort of perpetual access.
I guess in the event of an emergency and someone can get back there, even if I guess it were capped off or fenced off at the far ends, they can, occupants could, in theory, make their way pretty far away from where maybe a fire is taking place, because all of that's just wide open back there.
Yeah, no, we understand the way it is now. It's just the what ifs, but again, not that anybody's planning to do anything other than possibly develop further, south of you, beyond the billboard site.
Yeah, I believe, and Roy's, that's like a park at the bottom end. The Boyd Running Family Park is right at the bottom end of it as well.
Yeah.
So seemingly with that existence, it suggests like it should be there for a while. I can't speak to the plans of the city for the expressway right away there, but that zone behind our structure to the expressway, I would imagine would not really get developed at minimum. But yeah, beyond that, we've revised our plans to now incorporate the spiral staircase elements that would connect, each of the units to now have two ways out of the building. So we have a 2-hour rated enclosure for the single staircase. And again, these units are only about, 400, 500 square feet at most. They're all pretty small, as the lot is very, very small.
So if you were able to get out the back gate, you're able to pass the fenced in billboard area, correct? And get to the little 2-foot-high fence that along Front Street?
So yeah, this is the little 2-foot-high fence. Right. That's where you can lead directly to. If you look beyond,
Okay,
that's kind of like the way back there.
okay. And that corner of that gate is the back of the billboard property?
I believe, yes, that is correct.
Right.
How long is that from one end of the buildings to the other, that back area?
Are you asking for the open land?
Yeah,
Well, if our property is roughly 16 or 17 feet wide, they got
Oh.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, about 15 other structures multiplied by that. So it's a few hundred feet.
Mhm.
17 times 15 is 250 feet roughly. That might be kind of the distance from our property to Callow Hill Street if you're going back there. And then going towards the dog park, you probably have 50 feet or so, 50, 75 feet to get to that where that small fence is.
Mhm. Okay.
If you get to if you get all the way out to Callow Hill, is there a fence there? Or is that open?
Says open to Callow Hill.
I know, that's why I'm asking.
Yeah, so this is the Callow Hill side. There's a gate in the
There is a fence. Okay,
yeah, a fence there with a gate.
that's open.
Right.
Yeah, I think what we've talked about in times with, landlocked rear yards is being able to get that 50 feet away from the
Away from the fire.
from a fire in their building, which you really can do in either direction. You're short of somebody, restricting access.
Right.
John Dimes?
Can you hear me?
Yes.
Yeah, we need Dimes.
Oh yeah, I'm sorry. Yeah, I don't have a problem with it. I'm not a real estate expert too, isn't it? Isn't there some sort of real estate law once you start using some form of property for so many years, you kind of have a rights to it or easements created? If everybody's been using it for a decade or two, I don't know. Again, this is not advice, but the 50 feet, it looks like whether or not they can get to a public way or not, it looks like, I guess we could see dimensions on that or travel distance. Can they get 50 feet away?
Yeah.
Even if somebody fenced that in and they couldn't get to a public way?
Still got 250 feet on one end, right?
Yeah.
Yeah.
Yeah, I mean, I could pull it up on Google Earth and maybe use the measurement tool if you'd like for me to do right now.
No, you don't have to measure.
That's okay.
I mean,
You
yeah,
did it.
so-
That's fine.
yeah, based on that, I mean, I would be okay with it.
So,
Yeah.
all right, everybody okay?
I think we should
Can-
caucus.
I think we need to
Caucus?
caucus.
Okay,
Yep.
all right, we'll caucus.
Wayne, you're on mute.
I just sent him prompts to start the video and to unmute himself.
Can you hear me now?
Yeah.
Yes, sir, we can.
Okay. Okay, unfortunately, we can't give you the ability to go on somebody else's property. That's a state property, that's why we said before we needed an easement. We don't know what else we can do back there. Because we don't know if the state comes along and puts something in there or has to build there, what do we do then? So I don't know what other alternative we have. I don't know if you guys have something, but the thing is that we can't give you the right to trespass on somebody else's ground. That's the problem. And quite frankly, even if we do sympathize with you and if we wanted to do that, we think that the commissioner would shoot us down. That's where we're at.
Yeah, we feel from a functional standpoint, I mean, it works. There's a reasonable way to get out of there. However, it's not by, a route that is, guaranteed to be there in perpetuity, and that, it's just, it's an unfortunate precedent from
Yeah.
the department standpoint.
Okay, I guess I think it's defined as a right of way. Am I incorrect? That like the Delaware Expressway is just like a right of way, like kind of like another road is in the city,
It's a limited access right away where access to it is only allowed at specific locations as designated by PennDOT, which would be the road that you travel along.
Okay.
Brian, it's different than a street right of way, which goes up to a building facade on the sidewalk side. So
Correct.
It's a different interpretation. Okay.
Correct.
Okay.
We don't know what else to do, Gabriel. You know what I mean? It's that it isn't that we don't want to do it, but we don't have the authority to do it, on there. So. All right, pal.
Understood.
All right. Good luck, guys.
Thank you.
All right. Okay.
Okay, you can stop recording.
Okay.